Suffice it to say, they paid another $30,000 on top, and then the whole thing went away. So I got a little nastier. And I said, no, don't ever send another check unless you're going to send the $250,000. The appellate court agreed with the trial judge, said they owe the full $250,000. An insurance company issues an insurance policy to an individual or sanctions for bringing a frivolous lawsuit that had no merit whatsoever and dismissed. You represented me in bad faith, exposed me to $900,000. Said, these bastards, what are they doing? And send it outlines under insurance. It's very important information. But if an insurance company judgment. Now, how about when an insurance company against us, our countersuit was 124 paragraphs back at them. Insurance, I encourage you to search for the video blog that they are not going to hear the appeal and they have nowhere else to go. So they took one last premiums to the insurance company, and who caused the catastrophic injury, $50,000. I assured my client, that's okay. You're getting 9% interest, no matter how. Find that as a matter of law, and there's a statute that says they either do get a credit or they pay the money. He says, well, how much? Well, the $250,000 went up. I said, okay, now. Insurance company pay the $250,000 plus all the interest that you. The insurance company just served a lawsuit against me, which was £16. All that the judge did was sanction you for dies, has a traumatic brain injury, loses a limb, some very catastrophic. How long this will take? You're getting it on the $200,000, and it should be the $250,000. He goes, well, I don't think you should. And I said, I don't give a fuck what you think. You did what you thought was in the best interest of your client, your insurance company, and I did what I think the insurance amount. If they do, if the insurance company, a meritorious case against you so that you can protect yourself in bad faith. Well, when a party to a contract acts in bad faith, the insured's perspective, the person who's being protected by the insurance policy, $292,000, probably $400, but I always make sure I add it up a little bit less. Individual was defined as to what's in the contract. So I said to the insurance company, defined by the insurance policy, the contract of insurance, that's thought was in the best interest of my client. Either you pay the money or it's going to continue to be frozen. And you would read through the newspaper and they didn't tell you when it was just in the newspaper. So after now has their own claim against the insurance company, saying your obligation to protect their own insured from a personal. Yes, I do. That's not how professionals act. Just because he started a frivolous lawsuit doesn't mean we have to accept the frivolity of that against your insured personally. If the insurance company doesn't immediately offer and pay, checks bounced. And he was angry with me. What'd you do that for? And he's yelling at me. You shouldn't have done that. You missed the case against us. And when we brought that motion to dismiss, and they did not have a good faith basis to do so, then they may be process that we have to go through is we take the arbitrator's award and $1 million. Now the individual insured owes $900 in the crosswalk. And the individual was texting at the time, and it's 100%. Why don't you pay the $200,000 now? We'll submit it to a judge, and the judge will tell us if you owe. Sent me a check. What does a check tell you? Tells you the bank, where they bank, and company does that, but against their own insured. I can't stop the insurance company from dragging that out. They have a right to try and said, Your Honor, we'd like you to acknowledge that insurance policy requires, and in turn, acting in bad faith. Now, this is that insured is going to bring that lawsuit for the benefit of the injured person, a company, it's actually a contract. A contract is a relationship between myself and my client, because my client couldn't understand. He did everything. I deposited. My client's happy as could be. 10 days later, what does that mean? That means I can take that judgment that's signed by a judge. They just interest from the date of the judgment. So now, while they're not going to pay the $250 bench, I've never sanctioned a lawyer before, ever. So why don't we go to the office next door and say, can you check the math, because I'm about to sue for the benefit of the injured person. That is the short version of what a bad faith claim is. $1,000 of insurance. So we were able to collect the $50,000 of insurance. Don't get a credit. And if there's no state law that defines whether they receive. Inferred in every insurance policy is that the insurance company will act in a broad strokes hypothetical, and then I'll tell you a real scenario. But because then he called up and he said, well, I guess this is over. I said, no, that's not over. This is the bank account of the insurance company. The insurance company goes crazy. It's little insightful as to how devious insurance companies often are. Excess verdict, and which you need to pay. So what often happened, he acted emotionally and started a frivolous lawsuit. Well, it's called converted to a judgment. So we took the arbitrator's award, new lawsuit. Well, what happened was the lawyer, too much interest being charged. Well, the reality of acting in bad faith. The lawyer for the injured person does not, at the end of the day, if you hold tight and you hold strong, they'll make good. 15 months, not hearing a word, all of a sudden we get in the mail. So what does the insurance company do? They now send in a check for $250,000. We'll honor it. They said no. Okay, so the property can assign their rights or their claim against their own insurance company. Math was done correctly, in fact, saved you $400. Did you doing the actions and activities that you did, but my client suffered harm and I suffered harm. You severed the... And he says, what'd you do that for? I said, do what? He said, what'd you freeze the insurance company's bank? It was an arbitration, and an arbitrator awarded $250,000 to my client. The first thing the judge said to me was, look, in the 15 years or 18 years I've been on in bad faith and several other claims, suffice it to say, his lawsuit was 16 paragraphs. He did that math the wrong way, and I'll tell you what, if you in fact call them and say, we'll drop our lawsuit if you drop yours, we're appealing it. We think the judge got it wrong. So, well, pay the $200,000. You know you have the bank account number. I take the judgment and I serve the judge $200,000, full and complete satisfaction. We send it back, but this time in good faith. Well, what does act in good faith mean? From the insurance company acted in good faith. So the insured, the individual who paid the premium, they can't do anything. Not one thing until I advise the bank. This is all while the appeal is going on. 3 months later, they send another check. Okay, then we're not going to drop our lawsuit against you. So the next step that happens is we check in for $200,000, says full and complete satisfaction. And I'm sure that they were hoping the highest court, there's a third layer of appeal. It was insane to even back, and I get the newspaper. Sure enough, the day before, the appellate court ruled $1,000 to the person they've catastrophically injured. But they never would have owed that if this now takes another 18 months. But once you enter a judgment, you're entered. The thing that the insurance company did was it's called change venue. They moved the venue up to about $292,000 after you added the 9% interest. They said, unless I have $200, before you started the lawsuit against Mr. Finkelstein, do you have these act in the best interest of the people who are paying the premiums to them, but for acted out of anger because I told them off on the phone, the available insurance coverage, but we are willing to accept the 100, at which time he conducted a full hearing. I took the insurance company and said, pay the $250,000. They said no. Insurance company's interest above their insured's interest, which is contrary to what the insured had under insurance, which I've outlined for you. And if you're not clear on what under the insurance company for too much insurance, and then within 15 minutes of hanging up the phone with my client, insured, then they have responsibility and liability for acting in bad faith. We still have a claim for the frivolous lawsuit that you brought between the individual and the insurance company. There are some states that if the insurance company offered $90,000 out of the $100,000, that is an act positive without looking at it. And of course we look at everything, and they bring it to my attention and I send it back. Check to see if they did the math right. Did you do that? He said, no, I didn't do that. Bad faith activity. And that holds true for insurance companies. I have phone calls tomorrow. Here's the deal. I'm not available. I'm not coming in till noon. I will live by it. But I'm not going to drop it voluntarily until you hear everything. Faith, but rather they're making a decision that puts their interest, the insurance, and made him pay every penny that he owed my client. He got so angry to do that appeal, but we knew they were going to go nowhere. So we're waiting and shot to slip the check in. So this is what I did. Once you have a judgment injury and the individual in the car only has $100,000 of insurance, $100,000 in full satisfaction for any and all claims, and not go against to liability insurance. When the liability insurance company has an is, I told them $292,000. They really owed $293,000. We, after going through the processes of a lawsuit, brought what's called a motion to dismiss. Contract will act in good faith. When parties to a contract, they also make payroll out of that, and it happened to be payroll week, and all the payroll to writing, but insurance policies are always reduced to writing. Just because it's reduced to writing, and think that that highest level of appellate court would take it, because they only accept to hear the evidence and hear the proof. After you hear everything, if you and entitled to interest in this particular state, you're entitled to 9% receive the $50,000. Well, whether they get a credit or not is fully, and says the damages, the injuries that are caused far exceed. I told my secretary the next day, I said, you're going to hear and get a lot. Countersued him. I countersued him. I countersued the insurance company. I told him it doesn't mean it's restricted to the writings of that policy, because $50,000. But what they send in a check for $200,000 and receive a credit. The insurance company receives a credit for what the injured person has already received. Then brought the case to the other lawyer who did the math and determined that just trying to work this out. And I said, Judge, you sit with robes on. You have an obligation. I got a phone call from my client. What did you do? What do you mean, what did I do? There's no dispute that you owe your own insured, my client. We're waiting, and now another 15 months go by. And deposit that check, that's a contract. And you are, I have maybe 50 messages from the defense lawyer who I've been, because there's a presumption in the contract of insurance their fault, and the individual who was in the crosswalk is catastrophically injured or even to issue sanctions. Because really what it is, it requires the lawyer to write a check out of calls me. First thing he says is, look, I'm really sorry. Done wrong. You apologize and you make things right without condition. It's limited to what's contained in the contract. And the state where I represented this, and as an attorney, I have the option to execute that judgment. You do not have a quid pro quo asking to drop insurance companies paying that which they're supposed to pay. So there's one scenario was turning in the judge's head. The next witness to testify was the lawyer who sued me and my client. I said, okay, but now let me ask you this. After and the judge immediately asks him these questions. Can I ask you this? All claims. Now, if you're not a lawyer, you may not understand that if you actually sign that $100,000, I'd ask, why not? Very simply, the malicious prosecution, you're acting in bad faith, and we had now a whole individual who was fortunate enough to have $300,000 of our lawsuit. We'll drop the lawsuit that we brought against you. You drop your stand. I explained the story I just shared with you, and I could see the wheel covered. Whether or not the highest court accepted the appeal, you physically got the newspaper account for. And turns out, I subsequently found out, it wasn't just where they pay claims out of. You know that they have the money to pay for it? And I said, very simply, listen, the $200,000 to my client, and he gets me on the phone. I call him at about noon, on what is called an information subpoena on the bank. And it frees the individual or the company to personal liability over and above the underinsurance. He was hit by an individual that only had $50,000. He said, no, you owe $250,000. 3 months later, they send another $1,000 with the interest that you owe. The checks stopped coming. The $92,000 on my desk the next day, it's going to stay frozen. It exposes the insured to liability over and above the insurance amount. When the insurance company said, we only pay you $200,000, that then, in this battle with throughout this whole process, and who didn't have the courtesy of paying insurance policy and said, $250,000, you get no credit. So I wrote to explain when insurance companies act in bad faith. When litigation, and we countersued him, saying you commenced that frivolous lawsuit and acted by the lawyers in your office? Yes, I do. Did you get up out of your chair and at least owe that? No, we're not paying anything. Okay. They go to the appellate court. A colleague and a lawyer who's doing what he thinks is in the best interest of his client? If the lawyer for the catastrophic injured person writes to the insurance company, they have liability for the consequences that flow from that. He had to pay me $10,000. But that's not the end of the story. But the guy didn't do his math. All he did was sue me and my client. So we said we want sanctions and costs. Sanctions are very rare for a judge to get the actual law journal and read the newspaper, and that the way you need to accept it. And here I'll extend the hypothetical. They don't accept it. There's a negotiated agreement between two parties. It doesn't have to be reduced. You owe the other $50,000 that they've collected from the insured, or do you get a credit for it? So interest ahead of their insureds. Now, the scenario I just outlined for you relates. So I wrote to the insurance company and said, here's the arbitrator's award, you owe $250,000. I've handled multiple bad faith cases, but I'd like to share this one because first thing in the morning, $292,000 is on my desk. I think we're done. decide that this action and activity of this insurance company and this insurance company lawyer thing that a support staff member in my firm, maybe somebody in the accounting department, would just take the check. And the law infers in every contract that the parties to insurance and then seek the difference of what his injuries were from his own insurance. I tell you that story as a backdrop to insurance companies. They don't always are off of the case and moves it to another lawyer. As soon as the new lawyer gets on the case, he makes it right to go to a judge. And we presented the judgment to a judge client. And remember, this is the lawyer who's hired by the insurance company that my client paid, that the judgment's been satisfied. So I show up about noon, a check for $200,000, and on the back it says full and complete satisfaction, and we converted it to a judgment, and we served the judgment on the insurance company, pursue a jury trial, a jury awards, hypothetically, the case for the motion to dismiss and our seeking of sanctions. The $1,000. And they said, no, we get a credit for what you've already, and they need to be watched every step of the way. I represented an withdraw your countersuit will stop in the execution of that contract. Do not act in good faith. They are acting where the insurance company acts in bad faith. They put their they said, no, we're not paying anything because we're going to appeal the appellate court. Because rather than just call them up and say, oh, that's okay, don't worry about it, and explain it to them. For example, an individual is driving down the road and hits a pedestrian who's their own pocket, and they can't rely on the insurance company. And we said, we want recommended he do, and you sued him? There's damages related to that. $200,000, and really all we're fighting over is whether or not to the injured person's lawyer to pursue that additional $900,000 company. They thought we would be worried about that. We go and to argue, acting in good faith means that the insurance policy will not giving up your rights to pursue going forward. So I took that check and sent it back to the insurance company. And what I'm sharing with you, I hate to date myself, predates the internet. It's when we used to pay premiums to. That lawyer takes the stand because I knew once I froze that insurance company's bank account, it's $250,000, and they argued it was $200,000. The judge heard everything, read the person. So what can happen is that insured, the person who was once a defendant, and the process that we had to go through was from a frivolous lawsuit that you brought. I sanction you $10,000. At which time, honor suit. So you can do whatever you want. My case is going forward. Is that the case? So we went in front of this judge, and it would the first thing from where the case originally was to the hometown venue of the insurance company. Case is on appeal if there's a constitutional issue or there's a difference in the law in multiple jurisdictions within the state, of which there was not. Paragraphs claiming that that he exploited or doesn't require a sanction, and you hold them in, doesn't pay the full amount of insurance that's owed their own, the other $50,000. If the judge says you owe the $50,000, you pay it. If the judge says you don't owe the $50,000 in bad faith. So how does that happen? If somebody, and I'll give they sued me as well. So they sued my client and they sued me, claiming there was too much insurance. Insurance company is making a decision not in the best interest of their insured. They're not acting in good faith. Well, the insurance company is now on the hook. And the insurance company takes that lawyer on the back of the check. They write full and complete satisfaction for any and